A quorum being present, the Subcommittee on Higher Education and Workforce Development will come to order. Good morning, and welcome to today's subcommittee hearing on occupational licensing. I would like to thank members of the subcommittee and our witnesses for being here today as we discuss licensing and the ways we can encourage states to lift barriers to economic mobility and growth. Occupational licensing plays an important role in protecting consumers and ensuring high-quality service. In many cases, it makes sense that a professional would be credentialed to operate, like in the case of a doctor performing surgery or a pilot flying a commercial plane. But in other instances, the need for a license is more of a stretch. For instance, if you aspire to be a barber or an interior decorator, there seems to be less of an urgent need for the government to play a role in regulating your career, and yet government entities have disagreed. The number of jobs requiring a license has grown dramatically over the last several decades. In the 1950s, only 5% of workers were licensed. Since then, an economic shift to the service industry and concerns for consumer protection have led to a steady increase in professions requiring a license to operate. As a result, licensed workers today comprise about a quarter of the entire workforce, a five-fold increase. Because states are responsible for imposing most licensing requirements, the burden of obtaining a license varies widely from state to state. For example, it requires 233 days in New York to obtain a cosmetology license, while it requires 490 days in Iowa. These kinds of delays and inconsistencies have resulted in a confusing and anti-competitive patchwork of regulations which present a challenge to credentialed workers considering a move across state lines. Studies show worker mobility is critical for economic stimulation and wage growth. Yet, licensed workers are less likely to pursue an opportunity in a different state than their unlicensed counterparts. After factoring in the need to complete new education, undergo state-sanctioned testing, and pay new licensing fees despite their presently held credentials, many licensed workers ultimately forego opportunities in different states because the entire regulatory process is just too complicated. What is more, lower-income workers and consumers bear a disproportionate share of this regulatory burden because occupational licenses cost a substantial amount of money up front. Many cash-strapped workers may be prevented from entering a field, contributing to the estimated 2.85 million fewer jobs due to these requirements. Licensing can also lead to higher prices for consumers. It is believed that $203 billion in licensing costs are passed on to consumers each year, which especially impacts lower-income individuals. When House Republicans delivered on tax reform last year, it was to give American workers and families more jobs, bigger paychecks, fairer taxes, and greater opportunities. So far, 90% of Americans have seen more take-home pay, and the U.S. economy is experiencing strong gains as a direct result of tax reform. But some overly burdensome licensing requirements are putting a drag on these outcomes and slowing forward economic momentum. States should work to strike the right balance of placing licensing safeguards where they are needed and removing barriers and restrictions wherever appropriate. This has been a bipartisan issue in the past, with the Obama administration issuing best practices to states to minimize the burden of these regulations back in 2015. Hopefully, we can continue this bipartisan cooperation to ease the regulatory burden for more working Americans. I look forward to hearing from our panel of witnesses and from other members of the subcommittee today as we discuss ways to reform occupational licensing systems to spur economic mobility and growth. The subcommittee ranking member, Susan Davis, has an obligation with another committee this morning, and when she is able to join us, I'll recognize her for her opening comments as well. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I will now introduce our witnesses for this morning's hearing. Mr. Brian Snyder is the Secretary of the Illinois Department of Financial and Professional Regulation. Mr. Albert Downs is an Employment, Labor, and Retirement Policy Specialist with the National Conference of State Legislators. Ms. Rebecca Vallis is Vice President for the Poverty to Prosperity Program for the Center for American Progress. And Mr. Robert Mcnamara is a Senior Attorney with the Institute of Justice. I now ask the witnesses to raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize each of you to provide testimony, let me briefly explain the lighting system. You each have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time has expired, the light will turn red. At that point, I will ask you to wrap up your remarks as best as you are able. Following that, members will each have 5 minutes to ask questions. And I will recognize the witnesses now for their opening testimony. And first, Mr. Snyder, you're recognized for 5 minutes for your opening testimony.
Good morning, Chairman Guthrie and members of the subcommittee. My name is Brian Schneider, and I serve as the Secretary of the Illinois Department of Financial and Professional Regulation. Thank you for your interest in occupational licensing reform and taking time to hear testimony on this issue. My department is an umbrella regulatory agency overseeing almost all individual occupational licenses within the state of Illinois. Unlike many states which regulate through individual professional boards, we license and regulate over 1.1 million individuals in over 70 different professions, such as physicians, architects, roofers, barbers, and even hair braiders. This regulatory structure provides numerous operational efficiencies and a unique and holistic view of the regulatory landscape. It has made the need for sensible reform in the occupational licensing sector even more apparent. Our guiding mission is to protect the health, safety, and welfare of the people of the state of Illinois through the appropriate and tailored regulation of professionals. The underpinning principle of this mission is that government regulation through licensure is appropriate where unlicensed practice would result in public harm. However, often the question of does this profession pose such a danger to the public that government intervention is required is conflated with does the profession provide a benefit to the public. In Illinois, we have frequently seen groups propose legislation seeking licensure based almost entirely on the contention that their profession offers immutable consumer benefits, with only a generalized, unsubstantiated claim that public safety may be tangentially impacted. While there may appear to be no downside in requiring a profession to be licensed, overregulation where the public safety is not in question has tangible adverse consequences. Obtaining a license is often costly, often requiring thousands of dollars in education, exams, licensing fees, and continuing education. These costs create a significant barrier to entry for otherwise qualified individuals who could practice safely in an unregulated environment and disproportionately impact low-wage earners and those with criminal histories. The proliferation of varying state licensing regimes can also lead to decreased mobility across state lines, which negatively affects families of veterans or active duty military personnel. Licensure also creates a state-sanctioned monopoly, which leads to reduced consumer choice and increased prices. Recognizing these challenges, Illinois has undertaken several practical regulatory reform initiatives. For example, the department made a key change to our licensing process for barbers that would allow those being trained in a prison facility to obtain a license immediately upon release, as opposed to starting the licensing process only upon their release from custody. This seemingly small change allows those re-entering society to immediately start working, decreasing the likelihood of recidivism. This year, the department proposed Senate Bill 3395, which would ease interstate mobility issues for physical therapists. Instead of requiring the submission of transcripts, extensive educational history, and test score, as is currently required, the bill only requires the applicant to submit proof that he or she has been licensed for 10 years in another jurisdiction with no disciplinary history. This proposal ensures that the public is dealing with an individual who has a proven track record of safe practice while easing the regulatory burden for the licensee. Working with our legislature, we have also eliminated 11 specific license categories that historically had few complaints and posed little harm to the public. While we view this repeal of 5% of our license types a victory, we included several other similarly situated professions, but were met with hard-fought opposition from the associations who had initially advocated for these licensed monopolies. From this, we learned an important lesson. It is much easier to play defense against a new license type than to eliminate an existing license type. This session, we proposed a practical review process used by 19 other states in which an unregulated profession would have to undergo a thoughtful cost-benefit analysis prior to introducing legislation. The analysis would be performed by an unbiased, trained economist within the university system and would focus on the imperative question or whether public harm would result from the unregulated practice of the profession and what the potential costs to the public are if the profession were to be licensed. The analysis must be provided within a year and would be contained in a user-friendly report that would aid the legislature in making the determination whether licensure is necessary. Through these initiatives, we ensure public safety while creating a right-sized regulatory environment allowing for robust competition, interstate mobility, and job creation. Thank you for the chance to speak with you.
Thank you, Mr. Snyder. We appreciate you being here. Now I recognize Mr. Downs, 5 minutes for his opening testimony.
Chairman Guthrie and members of the subcommittee, on behalf of the National Conference of State Legislatures, thank you for inviting me to testify today. My name is Al Downs. I'm an employment policy specialist with NCSL. My area of specialty is occupational and professional licensing regulation. NCSL is a bipartisan membership organization serving all members and staff of the legislatures in every state, territory, and commonwealth in the nation. In 2017, NCSL, in partnership with the National Governors Association and the Council of State Governments, was awarded a grant from the U.S. Department of Labor to fund a 3-year assessment of licensure policy and practice at the state level. Our objectives are to identify licensing criteria to ensure there are not unnecessary barriers to work and to improve licensure portability across state lines. To achieve these, NCSL is engaging state policymakers through our 11-state occupational licensing consortium and researching the effects of licensing regulations on disproportionately impacted populations. Licensure is a form of regulation that requires an individual to obtain approval prior to practicing a given occupation or profession. Regulation by licensure is intended to protect the health and safety of consumers by preventing potentially dangerous or otherwise unqualified practitioners from entering an occupation or profession. Licensure is the single largest labor market institution in the country. More people need a license to work than are covered by the minimum wage or belong to unions. To obtain a license, individuals must meet state-specific requirements such as passing exams, paying fees, and completing minimum amounts of education. Along with varying requirements, one of the most significant differences between states is the structure of licensing authority. On one end of the spectrum, states like Colorado, Utah, and Wisconsin are arranged with a single agency or department that handles the implementation and enforcement of licensing rules for all or nearly all licensed occupations and professions in the state. On the other end, states like Arkansas, Kentucky, and Nevada grant independent licensing boards or commissions regulatory and enforcement authority over each licensed occupation or profession. The variation in requirements and licensing authority structure often stands to reason, as no two states face identical workforce needs, political circumstances, or government resources. In some cases, research suggests that licensing can benefit the public by limiting the risk of health and safety hazards from the incompetent practice of an occupation or profession. In many more cases, the risk of public harm is not well established, and research shows that consumer welfare is unchanged or sometimes reduced by licensing regulations. In all cases, economic data demonstrate that licensing can have negative consequences for job growth, overall employment, and consumer prices. Over the past several years, this growing body of research has led state policymakers to apply greater scrutiny to new and existing licensing proposals. In 2018, NCSL found that 2/3 of proposals to create new licenses or expand the scope of practice covered by an existing license were rejected by state legislatures. This represents a 12 percentage point increase over the average rate of rejection from the previous 2 years. Further, 11 states considered legislation to increase oversight of licensing boards, and 9 states considered legislation to require regulatory impact reviews of licensing rules. Currently, 31 states have nominal requirements for sunrise or sunset reviews of licensing regulations, and 10 of these actively perform both types of review. In 2017, 61 pieces of legislation were enacted across 24 states to reduce licensing requirements, expand options for meeting them, or create waivers for certain criteria. The U.S. Bureau of Labor Statistics recently reported that 8 occupations had been delicensed nationwide from 1975 to 2015. In 2017 and 2018 alone, 8 bills were enacted to delicense occupations across 7 states. NCSL has identified 3 broad categories of recent licensing policy change: occupation-specific, population targeting, and structural. First, when workforce demand or state policy goals for a specific occupation conflict with licensing rules, state policymakers may work to adjust fees, alter training requirements, or eliminate the licensing mandate completely. One such example comes from policymakers in Connecticut, who, after identifying which of the licensed occupations in the state did not require education, passed Public Act 1775, which fully delicensed them. Second, targeted waiver programs and other mechanisms of expedited licensing consideration can be developed to address the challenges of certain demographic groups. These approaches vary by the population being targeted, but one example is lateral recognition of licenses from other jurisdictions for military spouses. All 50 states have enacted legislation to address at least some part of the disproportionate burden licensing imposes on veterans. As a recent example, Wisconsin Act 319, signed into law earlier this year, reduces initial licensure fees by 90% for both military veterans and individuals with income below 180% of the federal poverty line. Lastly, structural reforms can improve the overall balancing of workforce development goals with public safety risks. Some common structural policy changes are establishing regulatory impact guidelines for new rules, conducting cost-benefit reviews on existing rules, and instituting active state supervision over independent boards. Earlier this year, Kentucky House Bill 465 proposed doing all three of these and would have created a new agency responsible for overseeing and reporting on all licensing board actions. More information can be found in NCSL's State of Occupational Licensing Report, which is included with my written testimony. We've also developed a database of licensing requirements for over 30 occupations across all 50 states, and next month we will be releasing a series of reports on the populations disproportionately disadvantaged by licensing regulations. We're glad to be a resource on this topic at any time. Thank you for the opportunity to speak, and I look forward to your questions.
Thank you very much. I appreciate your testimony, and we'll continue with the testimony, and I'll go to Ms. Velez for your opening, 5 minutes for your opening statement.
Thank you, Chairman. Thank you to the Chairman, to Ranking Member Davis, and to members of the subcommittee for the opportunity to testify today. My name is Rebecca Vallis, and I'm the Vice President of the Poverty to Prosperity Program at the Center for American Progress. With a license now required for 1 in 4 jobs in the U.S., the need to reform occupational licensing has attracted increasing and bipartisan attention. One notable bipartisan priority is addressing barriers that unfair licensing laws can pose for the 1 in 3 Americans with criminal records. This is an area ripe for reform with a great deal that Congress can do, and it's what I'll focus my remarks on for today's hearing. Following decades of mass incarceration, as many as 100 million Americans now have some type of criminal record. Having even a misdemeanor can present lifelong barriers to employment, far outlasting many individuals' formal sentences. The lifelong consequences of a criminal record stand in stark contrast to research finding that once someone with a nonviolent record has stayed crime-free for 3 to 4 years, her risk of recidivism is no different from the risk of arrest for the general population. People are treated as criminals long after they pose any significant risk of committing further crimes. Kids suffer the consequences as well, as nearly half of U.S. kids now have at least one parent with a criminal record. With more than 600,000 individuals released from prison every single year, the scale of the problem is tremendous and only growing, and unfair occupational licensing laws are a big driver. According to the American Bar Association, as many as 27,000 occupational licensing restrictions bar workers with criminal records. Lack of transparency, as well as variation across states, occupations, and how records are considered further compound the problem, as does use of vague criteria like good moral character requirements. Fortunately, a growing number of states, such as Illinois, have advanced common-sense bipartisan reforms. While states' reform approaches vary, my written testimony lays out several best practices, which the Center for American Progress joins its partner, the National Employment Law Project, in supporting. They include elimination of blanket bans in favor of individualized review of a license seeker's record, consideration of whether the record is related to the occupation or the license, and more. The Transportation Security Administration's recent reforms to how port workers' criminal records are considered also offers a noteworthy model on the federal level and is also discussed in detail in my written testimony. As momentum in the states continues to grow, additional action is needed at the federal level as well. A bipartisan licensing reform bill soon to be introduced by Senator Cory Booker would extend several of these reforms to federal licensing authorities as well as other entities that use federal FBI records in background checks. I'd like to briefly mention one other bipartisan reform gaining momentum in the states that goes hand in hand with licensing reform. While most states allow record clearing through petitions for sealing or expungement, many people with records can't access these remedies if they can't afford a lawyer. But an innovative bipartisan solution that is literally, as we speak, about to become law in Pennsylvania would short-circuit these barriers and bring record clearing to many individuals left behind. Pennsylvania's Bipartisan Clean Slate Act, which enjoys the backing of a broad range of bipartisan stakeholders, as well as 81% of the state's residents and even NFL players like Malcolm Jenkins, will enable Pennsylvanians with minor nonviolent misdemeanors to earn a clean slate by having their records automatically sealed once they've stayed crime-free for a set time. A growing number of states are now seeking to follow in Pennsylvania's footsteps, and Congresswoman Lisa Blunt-Rochester, a member of this subcommittee who I'm thrilled is here for today's hearing, is developing clean slate legislation for minor nonviolent federal records as we speak. In my written testimony, I set forth a detailed set of recommendations for Congress as it considers occupational licensing reform, but I'll highlight just a few in particular this morning. First, beware of deregulation dressed up as licensing reform. A first principle of reform must be do no harm. Broad deregulation efforts risk eroding standards that can actually be of significant benefit to workers, and in some cases also risk undermining public health and safety. Second, in order to do no harm, Congress must also avoid the creation of unnecessary new barriers to employment more broadly for people with criminal records. Federal laws are introduced nearly every week that include overbroad background checks and other new such barriers. Third, adopt the best practices laid out in my testimony to reform unjust licensing restrictions for workers with criminal records. Senator Booker's forthcoming bill will offer a promising bipartisan vehicle. Fourth, take action to clean up FBI records. Cleaning up notoriously inaccurate FBI record data demands action by Congress in its own right and has been a bipartisan priority for years. Congressman Scott's Fairness and Accuracy in Criminal Background Checks Act would take important steps in this direction. Fifth, and I'm almost done, Chairman, support federal clean slate legislation as a much-needed counterpart to licensing reform to help workers with records access jobs that don't require a license. And finally, don't mistake licensing as to blame for the entirety of struggling workers' labor market challenges. Amid an economy in which nearly half of U.S. households can't afford basics like food and housing, licensing restrictions are just one of many barriers facing struggling workers. While well-crafted reforms are an important step in the right direction, they must be part of a much larger agenda, including raising the minimum wage, ensuring paid leave and affordable high-quality childcare, addressing unpredictable schedules, and more to make sure all workers have a fair shot to make ends meet and get ahead in the labor market. Thank you for the opportunity to testify today, and I'd be happy to answer any questions.
Thank you for your testimony. I now recognize Mr. Mcnamara. You have 5 minutes for your opening statement.
Thank you, Chairman Guthrie, Ranking Member Davis, and members of the subcommittee. I appreciate the opportunity to testify, and I appreciate the attention to this incredibly important issue. My name is Robert Mcnamara. I'm a senior attorney with the Institute for Justice. The Institute for Justice is a public interest law firm that for more than 25 years has been at the forefront of the fight against unnecessary occupational licensing barriers. And I'm pleased to echo the other statements made here today when I say that this is an issue of widespread bipartisan agreement. The dangers of excessive occupational licensing reform may in fact be the only issue on which the Obama administration and the Trump administration seem to agree. Think tanks, left, right, and center, have detailed the huge burdens posed on workers and consumers and entrepreneurs by unnecessary occupational licensing barriers. And the question, I suppose, is, given this widespread bipartisan agreement, why have we not yet swept the field clear? Why do there remain significant barriers to new workers entering occupations, to new entrepreneurs starting businesses? And the answer, I believe, lies in where most occupational licensing restrictions come from. And in our lived experience, the push for greater occupational licensing restrictions mostly comes from the regulated profession itself. Vanishingly rare are the instances where a push for occupational licensing is spurred by consumer complaints or by media reports of abuses in an industry. Instead, all too often, what we see when we go into state houses across the country are members of a profession urging for more regulation, more licensing restrictions that will prevent new people from entering the market and competing with them. Once the licensing barriers to competition are set up, established members of the industry are free to charge higher prices, provide lower quality service, and otherwise act as many of us would act if we were free from the rigors of competition. As a result, occupational licensing remains the most significant labor market institution in the United States, an institution that, in the estimate of one economist, costs the U.S. economy 2.85 million jobs. And the question, I think, is what we are buying in exchange for those 2.85 million jobs. And all too often, unfortunately, the answer is nothing, at least nothing in terms of benefit to the public health or safety. Innumerable studies have looked at the benefits of occupational licensure in fields ranging from tour guides to dentists, and have not uniformly, but almost uniformly struggled to find any benefit to the public of more stringent licensing requirements. This comes at a cost not just of jobs to the economy, but of opportunities to workers at every level of the economic ladder, of opportunities to consumers to provide, to obtain better services or lower prices, and at costs to basic individual constitutional rights. At the Institute for Justice, we have persuaded courts to strike down occupational licensing requirements under the First Amendment to the Constitution, under the 14th Amendment to the Constitution, and while those are important victories, those simply illustrate, I think, the degree of overreach that we see in many state and local occupational licensing efforts. Those are cases where people could obtain the services of a pro bono lawyer and persuade a court that the regulation actually violates the Constitution. I would suggest that those are simply the tip of the iceberg in terms of unconstitutional overreach. And so the right question, I believe, when we ask what we're buying in exchange for these 2.85 million jobs, is what we're actually trying to achieve with occupational licensing. And at the Institute for Justice, we propose a basic two-step analysis. The first question, as Secretary Schneider alluded to, has to be, what is the harm to the public we're trying to prevent? What are we concerned will happen in the absence of government intervention here? And the second question, which is equally important, is what is the least restrictive means of answering that? Licensing is the most restrictive regulatory means available to a government. As laid out in my written testimony, there are a host of less restrictive means ranging from voluntary certification to registration to even less restrictive means that can answer these restrictions. And even in instances where licensing is justified, if someone finds licensing is justified, it's important to ask the question of what sort of licensing is justifying. What is the scope of practice that actually has to be licensed? Because all too often, even in occupations that are licensed in all 50 states, like dentists or engineers, we see individual boards reaching out to attempt to impose licensing requirements on activities that have no relationship to the core activities of dentistry or engineering that spurred the desire for that license in the future, in the first place. I appreciate the subcommittee's attention to this issue. I appreciate my co-panelists' attention to this issue. This continues to be a tremendously important issue of American public policy, and I appreciate the opportunity to address you today. Thank you.
Thank you very much. I appreciate all the witnesses and their testimony. I know one of the most difficult things here is when you have two committees meeting at the same time and obligations to both, and so it's great that we have Ms. Davis here, and I will recognize her now for her opening statement.
Thank you very much, Chairman Guthrie, for calling this hearing today and for the ability to offer this statement after our witnesses have spoken. I want to thank you all for being here as well. Occupational licenses can provide benefits both for workers and consumers, and when designed and implemented carefully, these licenses can benefit consumers by ensuring higher quality services and improving health and safety standards. As we have already heard today, states vary in both the types of licenses that they offer as well as the requirements needed to obtain a license. This can present a challenge for workers as they seek to enter licensed occupations. But the good news is that there is some bipartisan agreement at the state level on sensible occupational licensing reform when it comes to barriers for those with criminal records. Efforts to promote fair chance licensing laws have recently passed in states like Illinois, Delaware, Georgia, and Kentucky, and these laws promote thoughtful and targeted reforms in licensing to increase access for those with arrest and conviction records. One of the witnesses today will delve, and already has, into the details of these reforms. Thank you for that. Bills have also been introduced in my home state of California to improve access to a range of occupations by requiring fairer consideration of criminal records and removing blanket bans when someone has an arrest or conviction record. And I applaud these efforts at the state and local level. But as we know, the primary authority over occupational licensing comes from the states themselves. So while we should acknowledge that at the state level there are issues with occupational licenses, Congress is limited in what it can do with regard to states' occupational licensing laws without encroaching on states' rights. There are several things we can do, however, at the federal level to increase employment and break down the barriers many Americans face when trying to enter and re-enter the workforce. First, we can increase funding for workforce development and job training. Lack of access to high-quality job training can present a barrier for those who want to invest in themselves and increase their employability. And we can work in a bipartisan manner to increase federal investments in WIOA and CTE, but also encourage the private sector to invest in job training. And we can also remove the barriers to employment for people with arrest records and other criminal backgrounds, as we have heard already this morning. 1 in 3 Americans has a criminal record. People with a criminal past not only face barriers in obtaining a license, but they are also discriminated in employment decisions broadly. We can pass bills that address these barriers, such as the Fair Chance Act, which would ban the box, or Ranking Member Scott's Fairness and Accuracy in Criminal Background Checks Act, which would ensure that FBI records for employment accurately reflect the disposition of an arrest. Also, we can address discrimination in hiring and employment. We can guarantee that all workers, including LGBT workers, are protected under Title VII by passing into the Employment Non-Discrimination Act. And finally, we can pass, and I hope it's not finally, but we can pass legislation to help working people better balance work and family life. Critical to so many. Researchers estimate that 1.6 million people would be newly employed if we pass the Childcare for Working Families Act. And we could also add an additional 5 million working women to the workforce if we had a comprehensive paid leave policy like the one proposed in the Family Act. So as we have our discussion today with the help of our wonderful witnesses that are here, I would like to impress upon my colleagues that occupational licensing is just one issue that people face when trying to enter or re-enter the workforce. By all means, we should encourage our state counterparts to pass sensible, tailored reform, but we here in Congress should do more to tackle the other barriers workers face when trying to enter the workforce. So while I applaud the majority for calling this hearing and raising awareness of some of the abuses many states have engaged in with excessive licensing requirements, I certainly hope that we can talk more about the concrete steps the federal government can take at helping workers earn a better wage. Thank you all for being here, and I look forward to the discussion.
Thank you for your opening statement. We appreciate that. We'll now move to member questions. Each member will have 5 minutes to ask questions of the panel. I will first recognize the chairwoman of the full committee, Chairwoman Fox. You have recognized for 5 minutes.
Thank you very much, Mr. Chairman, and I want to sincerely thank our witnesses for being here today and giving us some very informative testimony on an extremely important topic, not just to this committee, but to many, many other people. This is actually something I've been interested in since I served in the state legislature. I understand that, Mr. Schneider, my first question is for you. I understand the responsibility of the Department of Financial and Professional Regulation is to prevent harm to the public. How does your agency consider potential harm to consumers or job seekers when determining whether or not to require an occupational license, and what the scope of practice of that license will be?
Thank you, ma'am. I think part of that is the current deficiency is that we get handed a licensing regime by the legislature, and the legislature doesn't yet have a thoughtful way to investigate just that very question. So it's interest groups that have their own self-interest in showing the need for legislature, and that's why we think it's so important that the legislature create a method to allow neutral, educated economists, public safety experts to advise the legislature before they take that step, because that's exactly the problem. The groups have no incentive to honestly answer that question, and the legislature needs to discipline itself to get that information.
I noticed you said an economist. I hope you have a mechanism for choosing the right kind of economist when you do that.
We have a good public university system in Illinois,
right.
So we can find people on both sides of the spectrum.
Right. Mr. McNamara, in your testimony, you do describe how industry insiders use overly restrictive licensing requirements to exclude competition. I think we all really understand that. How do you recommend that states differentiate between actual public safety issues and efforts by well-connected insiders to keep out competition?
I think the most important thing to look at is to look for actual facts, specific instances of harm being caused by the unregulated practice of an occupation. And that's where there's an advantage in the litigation work we do as distinct from legislative work. In litigation, there is discovery, there's the opportunity to cross-examine witnesses, and there's a truth-seeking function that allows you to get to the heart of exactly what the issue is, especially in many state legislatures, which are part-time legislatures, which are understaffed. They are left at the mercy of industry groups that come to them and say the unlicensed practice of interior design is dangerous. And the lack of a fact-finding mechanism and the lack of a consistent lobby for occupational freedom means that all too often those voices are given far more credence than they deserve.
We understand that issue here, too. Mr. Downs, in your testimony, you described the different licensing structures adopted by different states. And I know that North Carolina is looking at this issue a lot recently. How do the differences in states' licensing structures affect efforts to improve the portability of licenses across state lines? And we've heard a couple of examples here as it relates to veterans and veteran spouses. What are you doing to assist states to overcome the challenges associated with improving the portability of occupational licenses across state lines?
Thank you for those questions. To address the first part, I think what we see is the impact of varying licensing structure authority is mostly indirect on portability. Centralized agencies will have the resources to be in a better position to understand where other states are. But on the flip side of that, more decentralized boards may have the agility to enter into licensing compacts or other agreements or have reciprocity arrangements more nimbly than a larger agency would. To the second part of that question, NCSL has an 11-state occupational licensing consortium where we bring together policymakers from the 11 states to have conferences and develop policy action plans and exchange ideas to develop policies that will advance portability and reciprocity.
Too bad you don't have 50. Thank you very much, Mr. Chairman. I yield back.
I thank the chairwoman for yielding back, and I will now recognize the ranking member of the full committee, Mr. Scott, for 5 minutes for questions.
Thank you, Mr. Chair. Mr. Chairman, our hearing today covers an issue that, with few exceptions, rests with state legislatures. Licensing and regulations are enacted at the state level, so if we were to override any of those regulations with federal legislation, it would seem to me that that decision would have to be made, would have to replace. You just can't just override without some kind of replacement. I'm not sure that there's any suggestion that we ought to get into that business. There are some things on a federal levels, particularly the arrest and conviction records, that are federal issues. There are other federal issues like the fact that working people who want to work face violations of civil rights protections by incurring pervasive systemic employment discrimination. Others lack access to family support policies like quality, affordable child care. Others lack fair scheduling or paid family and medical leave. We have pending legislation for all of these issues, and hopefully we can make progress on that because those are true barriers to education. But there are several issues that have federal implications, and I'd ask Mrs. Vallis to indicate what the problem is with criminal background checks when they are inaccurate.
Thank you so much. So it's such an important issue, and I also just want to thank you, Congressman, for your leadership in this space. It's become a bipartisan area of growing attention and awareness that it's not just an issue of people being held back by their own criminal records. There actually are massive and notorious inaccuracies, particularly in FBI criminal background data. And so what that can result in is people ending up erroneously being held back by a record either that was sealed or expunged or by someone else's record in some cases. So it's a true travesty, and it's one that your legislation, Congressman, is deeply needed as a counterpart to many of the issues we're talking about today to address.
And thank you. Ms. Dallas, can you just say a word about the benefit of licensing and regulation to workers and consumers?
Absolutely. So we've heard a lot today about the costs of licensing to consumers and to workers, but it's also important to talk about the other side of the coin, and that is that well-designed and tailored licensing and standards can actually provides significant benefits to workers. For starters, higher wages, particularly for women and for workers of color. White women experience almost 12% higher wages if they have a license. For Hispanic men, it's 11%. For black men, it's 8% higher wages. Licensure is also associated with lower rates of unemployment, better working conditions, longer tenure on the job, lower rates of involuntary part-time work where someone can't get enough hours at their job. And I'll throw out one more statistic because I work at a think tank and that's what we do sometimes. And that's that working age adults are nearly twice less likely to be unemployed if they have a license. So important to factor in the impact that reforms, as we seek to help these workers, don't inadvertently harm the very workers that we're trying to help.
Thank you. Mr. Downs, in your study of regulations at the state level, what recommendations are being made for federal action?
NCSL is not going to be making recommendations. We are facilitating states in developing specific action plans to develop their own policy based on the needs of those states. Our position is that this is a state's issue. States can and are taking the steps to improve the licensing policy in their own states, but we will not be making specific recommendations.
Are you suggesting that we stay out of licensing altogether? Because basically it's a state issue, so you'll have no recommendations for federal action. Is that what I'm hearing?
Yes, sir. And we also, NCSL is not making recommendations for state action either, other than that there are issues here, and state policymakers should be taking a deeper look at how best to implement licensing regulations, and we're facilitating states in their actions to do that.
Thank you. Ms. Vallis, you indicated the effect of very old criminal records and the likelihood that someone would reoffend. You mentioned nonviolent. Do you have the numbers for violent offenders?
I don't have them with me right now. I'm happy to submit those following the hearing if that's helpful for the record.
Thank you. But you said after 3 or 4 years of no violations that a person's likelihood of committing a crime has regressed to the mean. Is that to the average? Is that what you said?
That's exactly right. And unfortunately, we still treat people as criminals long after they pose no greater threat than you or me or anyone else in the general population of reoffending.
Thank you, Mr. Chairman.
Gentleman yields back. I appreciate the questions, and I agree that I'll recognize myself for 5 minutes. I agree that we have limited jurisdiction here. We're trying to find the right place. I know there's some legislation that's been mentioned that maybe we can look forward to. I do appreciate Mr. Scott's work on justice reform, and we've talked offline and on the floor about some things we could do, so moving forward. But in the limit, I remember I was in state government. I was the chairman of the State Senate License Occupation Committee, so it was an interesting time. But I remember having to do an interior design bill because people who worked for Yum Brands, which is at that time was Kentucky Fried Chicken, Pizza Hut, and Taco Bell. Other states had licensing requirements for interior designers, and the people who worked in that corporate headquarters they could do a restaurant in Bowling Green. They couldn't go 20 miles south in Tennessee. So we ended up having to do an interior design law just so interior designers could go across state lines. So some of this has sort of been hinted at already, but I just want to kind of look on portability. So for Secretary Snyder first, in your testimony you shared your efforts to improve interstate mobility for physical therapists. and I congratulate you on that. And are there other measures in place in Illinois to improve recognition of healthcare credentials and licenses awarded in other states? And have other states or groups of states reached out to talk to you more about how they may be able to implement mobility?
Yes, thank you, Chairman. We're always looking for ways to share best practices with other states, and quite frankly, to take advantage of the work that other states do. So we're an enthusiastic participant, for example, in the Interstate Medical Licensing Compact. We hosted the inaugural meeting of that compact in Chicago. We're one of the first states to enact the law. And that's a way for a perfectly qualified physician who's doing work in one state, has no record, to more easily apply for licensure in participating compact states. So we think those opportunities are a great way to facilitate interstate mobility for licensed professionals. We've done similar work with respect to accountants and accounting firms, and look forward to expanding it to as many professions as possible.
It's interesting how this goes. I have a specific bill that's already passed the House and moved to the Senate that for people, healthcare professionals who travel with sports teams. So if you're at the University of Kentucky physician, you travel to play UCLA in California, and you have to treat one of your own players on your own team, you're actually practicing outside of where you're licensed. So therefore, the question is about medical malpractice insurance. Is that applicable to someone who's practicing not on somebody in California, but somebody that they traveled with? So those are the kind of things we're trying to work through. Got a couple other questions. Sure. So Mr. Downs, the Occupational Licensing Project has identified 34 specific occupations, including at least 9 healthcare-related occupations for consideration as part of your work. How will your work benefit healthcare providers or practitioners looking to recruit and relocate across state lines?
So in our facilitation of states developing their action plans to address some of these specific occupations that we identified, several states are looking at lateral recognition or licensure by endorsement, where you don't have to enter into a compact or reciprocity agreement, but the state develops a plan to basically accept licenses from other jurisdictions for licenses or for licensed professions and occupations that are in particularly high demand in the state. So one that we see come up pretty frequently is drug addiction counselors, given the opioid crisis that is affecting several states. The need for licensed professionals in that healthcare occupation is increased, and licensure by endorsement is being looked at in several states.
Okay, thank you. And Mr. Mcnamara, in your testimony, you describe how scope of practice restrictions can be used to shield selected practitioners from competition. What recommendations would you have for states considering reforms to their occupational scope of practice requirements?
I think the most important thing, sir, is to look carefully at the scope of practice of existing licenses, because licensing does beget licensing. You see defensive lobbying efforts. You brought up the example of interior designers. A lot of the push for interior design licensing came from interior designers who said, licensed architects are forbidding us from engaging in these activities on our projects, and so we want a license we can show them to engage in this activity. Now, the right answer is that those were perfectly safe activities that had never harmed anyone and shouldn't require a license to perform in the first place. But allowing the scope of practice of architects to expand beyond what was truly necessary for the public health and safety spurred lobbying efforts by interior designers, which in turn resulted in locking new people out of the interior design field. So I think the most important thing is to start with the existing licenses and take a very careful look at which activities are actually covered by that license and pare those activities to the minimum that can actually be justified.
Thank you very much. I only have 9 seconds, so I can ask another question. But Ms. Valles, your testimony was real important, and the employers are wanting these people too. So and I know they have to look at faulty hiring, and they have some things they have to protect themselves from as well. But we have to come up with a system, because employers are there with open arms wanting to give people an opportunity, because we have more jobs than workers right now. So we appreciate your testimony. And I've out of time, but I'll yield back, and I will recognize Ms. Davis for 5 minutes for questions.
Thank you very much, Mr. Chairman. And having chaired the Consumer Protection Committee in the state legislature of California, I know that this is primarily our state's responsibility for these licensing requirements. So I think, the question raises then, as we've been grappling with this morning, is, what is the federal role? And it sounds to me that partly from your testimony and your remarks as well, acknowledging that the licensing requirements are really one narrow slice of this in terms of the barriers that people face when they are trying to further their careers, actually. And so I wonder if you could, even though this is not licensing per se, talk a little bit about those barriers for paid family leave, for medical leave as well, and how they restrict mothers, but others' ability to enter the workforce. So what are these larger slices? How can we address those in a way that really provides some solutions at the federal level to address these issues?
Thank you so much for the question. I would say that every day, millions of Americans are forced to juggle work and family responsibilities, but unfortunately, this nation's policies have failed to keep pace with the needs of modern workers. So without family-friendly workplace policies, like you mentioned, paid family and medical leave, paid sick days, I would add, affordable high-quality childcare, balancing work and family, and I'm sure many of us in this room can sympathize, can really prove impossible. Without paid leave, new mothers are often forced to return to work mere weeks or even days after giving birth, and they can struggle to find time to get to the doctor on their own or for their baby's checkups. Many workers lose jobs because of illness or for needing to care for a loved one. And childcare now costs more than college at in-state colleges in many states in this country. A lack of childcare for many obvious reasons can be a significant barrier to employment. So you mentioned the Family Act, which would create a comprehensive paid family and medical leave insurance program in this country so that we could join the rest of the developed world in having paid family and medical leave. I would also point to a range of other policy solutions that would really go a long way towards addressing some of these problems, but given the limited time, the other bill I'll mention is the Childcare for Working Families Act, which, as you noted, Ranking Member Davis, would ensure that all families have access to affordable, high-quality childcare. One other problem that sometimes pales in comparison to these other issues of paid leave and childcare, which is well worth noting as well, is the issue of unpredictable and fluctuating schedules that can cause workers to not know from one day to 1 week to the next when they're going to be on call, and that can stop people from being able to balance their family responsibilities, find childcare. It can also keep workers from getting the second job that they need in order to pay the bills, and the Schedules That Work Act would go a long way to addressing this. So lots that Congress can do to address the broader picture here.
Thank you. I appreciate that, and they're all issues that we sometimes struggle to work on to find those solutions, but I think there are a lot of good ideas there. I wonder if you could also just quickly address the issue of the banning the box idea, and we were talking earlier about those who have had a criminal record and the barriers that they face through job applications, and what impact do you think it would have if we would prohibit federal employees and contractors from asking a job applicant about his criminal record until the final stages of the interview?
Thank you
What difference
again
would it make?
for that question. It's another huge and needed counterpart that congressional action is needed to address. I can speak to this issue not just from having studied it, but actually as a former legal aid lawyer who represented many of the people who faced barriers to jobs despite having significant qualifications, but having a record or even an arrest that never even led to a conviction, despite the presumption of innocence being one of the cornerstones of our justice system. Even an arrest can be a scarlet A for the rest of your life, and a big part of that is having to disclose on a job application up front before you've ever had a chance to introduce yourself to someone, to demonstrate your qualifications for that job, that yes, I have some kind of a criminal history. And so the Fair Chance Act would build on the tremendous momentum in the states that we've seen to give workers with records a fair shot at demonstrating those qualifications rather than having their resume thrown in the trash before they ever get a chance.
Is there good tracking research on that in the states that have been piloting or working with those issues to demonstrate that it's significant? I think actually about the military as well.
There absolutely is. There is preliminary and increasing research by the day as those policies have more time to take effect and to show real returns. There is research out of both Atlanta, Georgia, and also North Carolina that I would point folks to, finding that when these policies go into effect, people with records are absolutely hired at significantly higher rates, and they have that fair shot to become productive members of society again and to provide for their families, which is in so many cases all they really want.
Thank you. Thank you, Mr. Chairman, for that additional time.
Thank you. Gentlelady yields back. And I recognize Mr. Smucker from Pennsylvania for 5 minutes for questions.
Thank you, Mr. Chairman. I want want to start by thanking Ms. Val for your comments in regards to, over here, in regards to your work with those who've been incarcerated, and particularly for your mention of some of the things that have been done in Pennsylvania. I represent the 16th District in Pennsylvania, and I agree with you. There are a lot of barriers in place for those who have been incarcerated. One of the best things we can do is ensure that they're able to connect with a good-paying job to prevent recidivism. So your comments are well taken, and appreciate your work in this area. Those barriers, of course, are in place for many across the workplace. I want to go to Mr. Mcnamara and sort of reflect on the comments you made in regards to new licensing. I was a business owner for 25 years in the construction industry, and then served in the state senate, and saw what you described is exactly what happens. There are members of the industry who come in and want to create barriers to entry. And so, for instance, we had a proposal for a plumbing licensure, and it ended up being a partnership between labor, who had plumbers working, unions, and some large plumbing agencies who really were pushing to create barriers to entry. And same thing happens with project labor agreements, where in that case it's often labor who specifically are trying to create a barrier for many construction workers to participate in jobs. So we find a lot of ways to create these barriers to entry. We have in Pennsylvania a license requirement, and our governor, I give him credit, has recommended removing licenses for a number of industries, and perhaps one to highlight is that of hair braiding. It takes 300 hours in Pennsylvania to be able to be licensed, 300 hours of training, I should say, to be able to be licensed as a hair braider. And he has proposed eliminating that license, which I think there's a good case to be made for that. I do want to ask a question, though, and I have two questions. One is really, what is our role in the federal government in this? But my real question I want to start with is, while well, you had mentioned, I just said about businesses wanting to create a barrier to entry. I think there is a specific concern that businesses may have that I'd like to hear from you how it could potentially be addressed, and that is sort of the quality of the product that is being provided and consumers being educated in regards to that. So I think it's a legitimate concern for businesses. If I'm in business trying to provide a product that is of top quality, and consumers may not be aware of the differences in quality, what is the role? Businesses do that sometimes through associations, where they create more awareness of the product that is being developed, maybe through certifications. Do you think those make sense? Are they an alternative to licensing that are necessary?
Absolutely. I think those make an enormous amount of sense. You're absolutely right that the quality of the product matters, and consumers being able to know what a quality product is matters. But I think voluntary certification programs or even government-sponsored certification programs allow businesses to communicate that they've met a certain standard to the public, while still allowing the public to choose whether they think that standard matters or whether they think, in this instance, the certification requirements have gone too far and don't actually have anything to do with quality.
Thank you. And then would you get back to what do you think is the federal role? As we look at this, we see the differences across states. Is there a role for the federal government, or should this be entirely left to the states?
It's undeniably true that most of the action here is going to be with state and local governments, but there is in fact a federal role in the scope of occupational licensing. One example being the federal antitrust laws. The Supreme Court held just a few years ago that state occupational licensing boards can be held liable for their actions in restricting competition in the occupational licensing field. Senator Lee, I know, has proposed responding to that ruling with what's called the Restoring Board Immunity Act, an act that would give these boards their immunity back in exchange for the states creating some kind of review commission, whether it be the courts or an administrative body, to examine whether the regulations the boards are putting forth are actually aimed at protecting the public safety or whether they are simply engaged in economic protectionism. So it's mostly a state issue, but there is in fact a real federal role.
Thank you.
Thank you. Gentleman yields back. We are, I guess, 11:30 to our estimating vote, so we're going to try to stick right to the 5 minutes if we can from now. I think we've been a little lenient on both sides, so we're going to try to stick to that. Mr. Takano, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Before I begin, I'd like to push back a little bit on the comment made earlier by my colleague on the other side about project labor agreements being a barrier to entry. I can attest to the fact that the project labor agreement that we implemented at Riverside Community College, where as a trustee, there was no evidence that it inhibited access to the contracts. In fact, the preponderance of contracts went to non-union companies. Project labor agreements merely assure that there's no cheating and that there is a certain small percentage, 1 or 2% of the construction budgets of a public agency that are devoted to enforcing fair labor laws and making sure that the workers are adequately paid and that they're the bidding process is fair. So I want to push back on that pretty vehemently. Ms. Valles, in your testimony, you mentioned that at a time when almost half of the U.S. households can't afford basics, occupational licensing restrictions account for just a very small piece of the barriers workers face today. Is that correct?
That's correct, Congressman.
And so it kind of defies logic that we would be spending so much time, staff time, congressional resources on a topic that is such a very small piece of the access to employment. This licensure, it's a very obscure little piece of policy making, and the New York Times recently published an article about pregnancy discrimination, and they shared stories from women who work in all types of U.S. companies, from Walmart to Wall Street. And why I bring this up is that I think we need to shift the topic to far more consequential barriers to employment. Regardless of where these women worked, pregnant women were often sidelined when they asked for accommodations. They were passed over for promotions or even fired. In light of this article, and since we are looking at barriers to employment today, what can we do to help pregnant workers from discrimination?
Thank you so much for the question, Congressman, and I would agree with everything that you just noted. I think it's important that we be having a broader conversation about the systemic discrimination that holds so many workers back in so many other ways as well. It's an important first step to be talking about bipartisan areas of agreement for occupational licensing reform, but I would agree that it is a much bigger picture here. So I would extend your important point beyond just pregnant workers, and I would include that several groups of workers face significant and persistent discrimination in hiring and in the workplace. Notably, this also includes, in addition to pregnant workers, workers of color, women, and pregnancy is a big part of being a woman in the workplace for many of us at some point, older workers, workers with disabilities, and LGBT workers as well, as the ranking member mentioned. Just to put a number to this for anyone who thinks discrimination ended years or decades ago, a recent study in the Harvard Business Review found that hiring discrimination against black workers hasn't declined in 25 years. I'll let that sink in. The result is persistent gaps in unemployment rates, in wages, in poverty rates, and in economic mobility. And so in addition to the measures that we've been discussing today, a broader range of legislation has been introduced to address many of these gaps. For example, the Equality Act, also sometimes called ENDA, would do a tremendous amount to ban discrimination on the basis of sexual orientation and gender identity. And a range of other policy solutions as well would do a lot to close these gaps, whether that's raising the poverty level minimum wage, supporting a federal job guarantee, particularly for disadvantaged workers and in distressed communities, strengthening collective bargaining, protecting and fully funding the EEOC, which is responsible for enforcing laws that prohibit employment discrimination against many of the groups we've mentioned, including pregnant workers because of their being women, expanding access to job training and apprenticeships, paid leave and childcare we've talked about, and also importantly, ensuring access to health care so that workers can stay healthy and succeed in the workforce. So I hope that all of that's on this committee's mind as we talk about these issues.
And Ms. Vyas, all of the things you mentioned, all of the policy measures, the federal government has a clear responsibility to legislate in these areas. Is that not correct?
That's correct.
And I mean, there may be some topics at the edge of licensure, but really licensure is really the province of the states, and why this committee is spending all this time on licensure defies defies logic. So anyway, I yield back.
Thank you. I appreciate the gentleman yielding back, and I recognize Mr. Estes from Kansas for 5 minutes for questions.
Thank you, Mr. Chairman. Mr. Snyder, one of the things that talking about in terms of the licensure requirements, and I believe it was mentioned by the chairman earlier around mobility across state lines, and what are you seeing that are some of the better practices or things that have worked in that regard of actually being able to be portable?
I do think interstate compacts, interstate agreements work. Licensure by endorsement works, provided the individual who's seeking to come to my state can demonstrate that they have had successful practice in another jurisdiction. Obviously, making some accommodation for folks who work in the military who go where our government tells them to go and yet need to find a job when they're in my state, making some accommodation for them, it would be critically important, I think, for the question of mobility.
Thank you. Another question is you looked at going through licensing categories that you eliminated. How did you go through the process of which categories made sense and appropriate to maintain, and which categories were a little bit more, less of a need and more appropriate to not have restrictions around licensing?
You know, we examined the historical data that we had. So many of these occupations had been licensed for decades, and we would look at how many complaints have we received in that period of time. And, you know, at some point in time, we like to think common sense can take hold. If no one's complaining about this, there's simply no activity, the license really isn't doing much, and there's no reason to believe that safe practice can't continue without the license. So that was data that we had that seemed very important to us as how are you performing, and if you're performing well without much oversight, why do you need even the possibility of oversight and all of those costs?
Did you also include categories around things like education and the qualifications of an individual to perform in that?
Yes, certainly. You know, if there's no real meaningful level of qualification associated with the requested licensure, then it doesn't make much sense. It's unclear to us what we're enforcing, quite honestly. What would we be enforcing?
All right, thank you. Mr. Downs, one of the questions we talked about is the number of states that have increased their oversights on licensing boards, and as part of that, maybe implemented new sunset or, in some cases, provisions that actually end those licensing requirements. And can you talk a little bit about that in terms of how that's valuable and useful moving forward?
Absolutely. So I think Mr. Snyder brought up an excellent example that in his state they had the data to make those decisions about which licenses were appropriate for certain occupations. And in many states, particularly states that have decentralized board structures, that data either isn't collected at all or is not housed centrally. And state policymakers are beginning in many places to try to collect that data so those decisions can be made. That the sunrise and sunset reviews are actively being done in 10 states right now. I mentioned in my testimony that several other states in the last year have looked at implementing similar reviews. And basically, those reviews, when legislation is proposed to create a new license or an existing licensing board proposes expanding the scope of practice or developing a new rule, an independent agency would be responsible for doing economic impact analysis, looking at historical complaints, things of that nature, to determine if the expanded license or new license is warranted.
Thank you. Mr. Chairman, I yield back.
Thank you. The gentleman yields back. The chair now recognizes Ms. Blunt-Rochester from Delaware for 5 minutes for questions.
Thank you, Chairman Guthrie and Ranking Member Davis. And I want to thank the witnesses so much for your testimony, especially on this topic of reducing barriers to economic mobility and growth. And as was stated earlier, nearly 1 in 3 Americans have some sort of criminal record. Criminal records present numerous barriers to employment, and as also was stated, not only does it impact the individual, but it also impacts their family. Estimates of the costs of the barriers to our economy are $65 billion per year. Mr. Chairman, I'd like to enter into the record a summary of the Center for American Progress report, One Strike and You're Out, that discusses how a criminal record presents a barrier to employment.
Without objection, so ordered.
Thank you. My question is really for Ms. Vallis. You know, as you were talking about this, you talked about the legislation that we're working on, Clean Slate. And can you share, we've had a lot of discussion too about the role of the federal government versus states, and in this area of criminal records and our Clean Slate legislation, can you talk about why this legislation is needed on the federal level?
Thank you so much for the question, Congresswoman, and thank you for your leadership in this area. So we've talked a lot about the role of the states. We've talked a lot about what is Congress's role. And here, I think this is a beautiful example, yet again, of Congress having a tremendous opportunity to learn from success in the states and then apply those principles where there is a federal role. So I mentioned that there's been this tremendous bipartisan multi-year adventure in Pennsylvania, and I think the congressman from Pennsylvania for loving that state as much as I do, where right and left have come together and agreed that no one should have to spend the rest of their life serving effectively a life sentence to poverty and joblessness because of one mistake they made or because of one brush with law enforcement that never even led to a conviction. And so a lot of the criminal justice reform problem really is a state problem because of state criminal records, but people walk around with federal records as well. And that's where we you as Congress and we as the folks in this room having this conversation today have a tremendous opportunity to learn from Pennsylvania and other states who are taking that clean slate approach to state records and now to transport that up to federal nonviolent minor records as well, which currently there is no remedy for people who have, for example, federal arrest records. There is literally no way you can get that off of your record in federal law.
You know, I'd love for you to follow up on the process that they went through in Pennsylvania and the lessons that we can learn in Congress, particularly talk about some of the partners that were involved and just how this process worked. What did they do that we can learn from?
Thank you so much, Congresswoman. So the Pennsylvania, I refer to it as an adventure because I have to say it's a time where it seems like right and left can't agree on much of anything, but this has been a rare bright spot of not just bipartisan, but really transpartisan consensus. We've seen groups like FreedomWorks that I don't think FreedomWorks and CAP agree on much. I think we know pretty much to talk about criminal justice reform as one of the only areas we agree, coming to the table together with groups like the ACLU, the NAACP, but also groups like Right on Crime and Faith and Freedom Works. We've seen law enforcement enthusiastically supporting the clean slate approach because they don't want to see the courts continue to get clogged up by these petitions for expungement and sealing that are such a burdensome workload for the courts. And we've seen employers, as the chairman mentioned, come to the table as well and say, we've got a skilled worker shortage. We don't want all these workers shut out of the labor market. We need them working for us. So it's been a tremendous group of folks that I think only got more interesting recently when the NFL decided they wanted to get involved, and folks like Malcolm Jenkins threw their voices in as well and said this is the right step.
Excellent. And lastly, could you tell us how Clean Slate would be helpful to workers who are trying to re-enter the workforce and even obtain an occupational license?
So Clean Slate, as I said before, really is a much-needed counterpart to occupational licensing reform and fair chance hiring and many of the other policies we've talked about today, cleaning up FBI records. And the reason for that is that if you, and I can say this from my perspective as a former legal aid lawyer, we turned away people every single day because of inadequate resources. We couldn't represent the many hundreds and thousands of people coming through our doors who were unable to access the remedy of expungement or sealing because they couldn't afford or find a lawyer. And so they were unable to navigate the Byzantine process in the courts, and they would end up having to spend the rest of their life with that sentence hanging over their head to poverty and joblessness that is the minor criminal record. Clean Slate would bypass all of that through automatic sealing once someone has remained crime-free and thus proven their rehabilitation.
Thank you so much. I yield back, and I hope Mr. Smucker will join me in our clean slate effort.
Thank you. I thank the gentlelady for yielding back, and I now recognize Mr. Banks from Indiana for 5 minutes.
Thank you, Mr. Chairman. As a veteran of the war in Afghanistan myself, I have seen firsthand that our men and women serving overseas pick up a number of skills that are applicable to professions that currently require a license. In my home state of Indiana, the Professional Licensing Agency has recognized this and has worked to develop a military experience pathway for military service applicants. In addition, though, the federal government, under the Federal Department of Transportation, has developed the Military Skills Test Waiver Program, which allows veterans who drove heavy-duty vehicles to bypass the road test portion of their state's CDL exam. So my question, we could begin with you, Mr. Mcnamara. What other occupations would be ripe for military skills test waivers? Mr. Mcnamara?
Thank you for the question, Congressman. I think that's an excellent question. It's an excellent example of how we can look to other things that are not the state's prescribed formal education program to ensure that there is a certain level of competence. And one thing about the military is that essentially every skill that is needed in the civilian world is practiced by someone in the military. And I think looking to military experience, but also looking to unlicensed experience of people practicing in states that don't have a license is something that could be applied to nearly every occupation. I know the VA, for example, has been aggressively looking for ways to expand ways for VA doctors to travel across state lines without worrying about each individual state medical board. And I think this is an important thing to talk about as we talk about what these laws are actually achieving. And to the extent what they're achieving is keeping people who have already demonstrated these skills out of the marketplace, that is a net loss for everyone, and that is something we have to avoid.
Any other easy, specific examples, quickly?
I'm happy to give some thought to it and submit further testimony, but I think everything from barbering to commercial driving to law enforcement, to be honest, all of which are licensed at the state level and all of which can be practiced by people on active duty.
Ms. Vallis, you have a quick, easy example of a military test skills waiver that could be provided?
You came with the hardest questions, Congressman.
That's what I try to do.
I don't have anything quick and easy, but I would echo my colleague in offering to follow up.
Okay, Mr. Downs.
What we have seen in addition to the CDL licensing that you mentioned is electricians licensing for folks in the military who practice those skills, several medical professions for folks who have been medics in the military, offering expedited or waiving the education requirements for licensing in those professions.
Mr. Schneider.
Roofing comes to mind. We license roofers for some reason in my department, and that particular skill was probably taught in building military buildings, so that might be one to add.
Are there examples in your state of ways that we could support our troops when they come home by?
Oh, for sure. You may see a military experience pathway from my department's legislative proposals next session if I have anything to say about it, because we need to create those pathways.
Can you tell us more about what that might look like, or any specific?
We'll probably be looking to our neighboring state, your home state, to see how if they've done it. That's one good thing about the state system is we can look to see what others have done and then just follow in their successes.
Thank you very much to each of you. It seems like common sense. Our men and women who serve in the military acquire significant skills, yet when they come home, they find such significant roadblocks to being able to do what they do when they move from state to state. And it seems like a common sense opportunity for the federal government to be involved in an appropriate way in an area that we should otherwise delegate to the states. So with that, I yield back. Thank you.
I thank the gentleman for yielding back, and the chair now recognizes Ms. Adams from North Carolina for 5 minutes for questions.
Thank you, Mr. Chairman, and thank you, Ranking Member, and thank you all for your testimony today. The issue of occupational licensing is one in which workforce development stakeholders in Charlotte-Mecklenburg County are keenly interested, and I represent that area. Ms. Vallis, Mr. Mcnamara states that we must begin with the idea of reducing the number of licensing requirements. What are the harms that can occur when there's an overbroad approach taken to occupational licensing reform at the state level?
Thank you so much for the question, Congresswoman. As I mentioned in my testimony, I think there is a lot of bipartisan agreement about what occupational licensing reform can look like, and we've heard about a lot of those bipartisan approaches. I think we do need to be cautious that we not move forward with reforms that could actually hurt the very workers that we're intending to help by erasing standards that can help them enjoy higher wages, better working conditions, lower rates of unemployment, and all of the other associated benefits with licensure in a well-designed and well-crafted policy context. I would also urge some serious thought to be given to public safety and to health. I know that we've heard a number of times today about how, the concerns about public safety and health are overblown, but I think that some of the types of areas where one might not think that public safety or public health is implicated often are. And so I'll give the example of, say, an elevator mechanic. And I'll share a story of someone whose life hung in the balance because of a lack of licensure. Deborah Jordan was dragged up 8 floors of an elevator shaft in a Brooklyn medical center. Her arm and leg were irreparably crushed. A repairman had incorrectly and unsafely disabled a safety switch that would have prevented the elevator from moving while its doors were open. Hers is just one of 53 similarly horrific elevator incidents just in one part of New York City in that year alone, and the landscape was that New York State did not require elevator mechanics to hold a license or to have any real training requirements. So I think we need to be thinking very, very seriously about what implications, not just for workers, but also for public safety and health, might be triggered when we start to look willy-nilly at where can we get rid of licenses.
Thank you. Organizations such as Charlotte Works in my district are concerned by actual issues in our licensing regime, especially related to consistency around training and testing. So can you speak to the impact that variations in an occupational licensing scheme would have on preparing students for such fields?
It's a terrific question, and Congresswoman, I'd be happy to follow up in greater detail. I would say that I think consistency and uniformity is an important principle as we think about occupational licensing reform. That's been a real bipartisan priority at the state level, and I know it's something that has a lot of bipartisan support in Congress as well. And that's particularly the case when it comes to the barriers that people with records can face because of tremendous variation across not just state approaches to licensing, but also within states. There's tremendous variation across different occupations, different licensing boards, the ways that records get considered. And so all of this can create tremendous confusion and lack of information to workers who in some cases end up wrongfully thinking that they might not qualify for a license. So standards and uniformity are hugely important here.
Thank you, Mr. Chairman. I yield back.
I thank the gentlelady for yielding back as that is the vote on the floor, so we should have a few more minutes. So I will now recognize who's waiting on the committee, Mr. Ferguson from Georgia, for 5 minutes.
Thank you, Mr. Chairman. I appreciate the opportunity to join this subcommittee today for this hearing, and thank each of you for your time and expertise in coming before us. I want to discuss a very specific barrier to economic mobility today, and that is the state laws which allow states to revoke professional or deny professional licenses simply because someone falls behind on their student loan debt. In 19 states across the country, including my own home state of Georgia, there are laws on the books that allow the states to take someone's license if they default on a student loan. As we've talked about it today, occupational licensing has grown to over a quarter of the workforce, and many of these licenses are in fields of healthcare, education, and public safety. I believe that it is completely contradictory to think that someone can have their license revoked and still earn a living and repay their student loans. Today, I joined with my Democratic colleague here in the House, David Cicilline, to introduce the Protecting Jobs and Opportunity for Borrowers Act, as we call it the Jobs Act. And beginning 2 years after enactment of this bill, it would prevent states from suspending or revoking licenses, professional teachers, some of the healthcare licenses, solely because they have defaulted on a student loan. And this bill was also supported on the Senate side by Senators Rubio and Elizabeth Warren. So this is a bicameral, bipartisan effort. Mr. Downs, in your testimony, you mentioned that having a professional license is an employment gateway. Based on that statement, would you care to comment on what we're trying to do with this bill, or the importance of removing these barriers?
Yes, sir. And Mr. Schneider's state is one of a few that have recently enacted state-level legislation similar to what you're attempting to do at the federal level. I think we see many state policymakers who are in agreement with bipartisan colleagues that those are the kinds of requirements that need to have the most scrutiny applied to them at the state level. I think that there are many states who have already taken steps to implement that, and there are many more that will be doing so in the next legislative session.
Mr. Mcnamara, would you care to weigh in on that?
Absolutely, thank you, sir. And I certainly applaud the legislative effort. I think it's undeniably correct, and I think in a way it goes to the heart of how we should be talking about occupational licensing. Occupational licenses are meant to be a means to protect the public health and safety. When a state licenses a nurse, the state should be concerned with whether or not the nurse is a threat to the public health or safety, whether she's a competent nurse. It shouldn't be turned into a tool of punitive debt collection. That's not what it's for, and allowing occupational licenses to move beyond their core purpose is a threat to, I think, everyone's right to earn an honest living.
Yeah. I agree. I think it is just absolutely ludicrous to expect someone to go get a job to repay a loan when they don't have a license. I mean, how are you, even if it's something like a driver's license, how are you supposed to get to work to earn a living to repay the student loan? So I'm glad to hear that y'all support that. And, look, I've got deep reservations about the federal government owning 92% of all student loans. With that being said, student loans now are currently a federal program, and I do think this is an area where we can be helpful. I look at what we've done with things like the Prosper Act, where we are trying to streamline and simplify the federal loan program, and I think that's a big step. But I think we've got to move beyond sort of an outdated model of patchwork state laws that really tell so many of our folks, we're not going to even let you have an attempt at a job by denying you this license until you repay the loan. I mean, truly it's a chicken and an egg kind of thing, and in this particular case, it looks like we're killing the chicken and frying the egg, and nobody's got a chance to win. So I just want to say I think this is an important topic. I think giving people opportunities to take advantage of what is truly a booming economy is important. And again, I want to thank each of you for being here. And Mr. Chairman, I yield back.
I thank the gentleman for yielding back. Reminder there's a vote on the floor. Mr. Krishnamurthy is recognized for 5 minutes to ask questions.
Thank you, Mr. Chairman. Thank you, Ranking Member. First of all, I'd like to ask for unanimous consent to enter a letter from the AICPA into the record.
Without objections, order.
I also want to thank our distinguished witnesses for participating this morning. Thank you for coming. As the only member on this committee from the great state of Illinois, I'm pleased to welcome Mr. Schneider from the Illinois Department of Financial and Professional Regulation. I know I only have a couple minutes before vote, so I'll get right to it. Mr. Schneider, in 2016, the Illinois legislature, as you know, passed an overwhelmingly bipartisan bill, HB 5937, which includes fair licensing protections. First of all, can you tell us about the protections for individuals who may have a criminal record?
Well, we have never, there are very few people who are ever denied a license because of a criminal record in my state. We think in certain cases it's important that we know about that record, that we talk to the applicant to make sure they understand their new responsibilities. What we were finding, though, is people were confused. People saw the question, we asked the question, and they figured they had no chance, and they either didn't apply or they abandoned the application after applying. So our focus has consistently been on education, and where appropriate, just not paying, just not looking into certain types of offenses. And our legislature, of course, has done a great job there in making sure that certain types of offenses are no longer considered at all. And even when they are considered, we make sure people understand that it is not a barrier, it's not an absolute barrier, so please proceed with your application. So communication can do an awful lot.
I know it's a little bit early, but how are these fair chance reforms working for Illinois workers so far? What kind of information or data do you have?
We don't, I don't want to mislead anyone. We don't have, hard data. We have some anecdotal data about, people who have told us, boy, I didn't think I had a chance to do this. We had anecdotal stories of, we have barber colleges that the state pays for in state correctional institutions. And when you would ask people taking the classes in those state correctional institutions that we're paying for, do you look forward to working as a barber when you get out? And they'd say, well, I can't work as a barber when I get out because I can't get licensed. So they sort of missed the point that we're paying to train you and paying to educate you, but they didn't think that they could do it. So our program to get people licensed before they leave prison, anecdotally, seems to be creating some job opportunity, and we hope to build on that success.
Great. Thank you so much, and I yield back.
I thank the gentleman for yielding back. Seeing no other members seeking time for ask questions, I would like to thank the witnesses for taking time to testify. Sorry, we're going to run out as soon as we adjourn to go to the floor to vote, but I would like to give, if any, time for Ranking Member Davis for any closing remarks.
Thank you, Mr. Chairman. Just very quickly, I would like to enter into the record 3 reports that demonstrate some of the barriers to economic mobility for many workers. Report from the National Employment Law Project quantifying the impact of FBI criminal records database on working people. A report from the Center for American Progress finding that 1.6 million workers would be able to enter the workforce if Congress passed the Childcare for Working Families Act, and a report from the Department of Labor finding that if the U.S. implemented programs like a comprehensive paid leave program, an estimated 5 million workers would be able to enter the workforce. Clearly, there are plenty of areas that we have a federal role, and I think we want to focus on those in addition, and I thank the witnesses today.
Thank you. Without objections to order, they'll be entered to the record. Also say thank you all for being here. It's been very informative, and I think a lot of us have stuff we can agree on and work together. So without any further business before the committee, without objection, there be no further business. The subcommittee stands adjourned.